Good morning, friends. How are you? Please be settled. I am discussing important topic regarding special petition. My question is, can a new plea be raised for the first time in the special petition? My answer is partially yes. Yes, in the sense a new plea can be raised for the first time in specially petition to the Supreme Court of India if they are pure question of law. This is allowed under Article 136 of the Constitution. I am going to little bit explanation. The Honorable Supreme Court can entertain new grounds in an SLP if they are pure questions of law that does not require additional evidence. The court can decide on these pure questions of law based on the facts already on the record. The court has clarified that filing a cross objection is not necessary. Additional grounds can be argued at the time of hearing with leave of the court. Supposing there is plea regarding lack of jurisdiction, a plea that an application was barred by limitation, a plea that involves a question of law that does not require additional evidence. So these can be raised. Further going into detail, uh, please bear with me. I am setting my. Now coming to plea of facts. The Honorable Supreme Court has by and large followed the practice of Judicial Committee of the Privy Council and that of the federal courts in not allowing new points of the facts to be raised for the first time before it. If those points were not raised before the lower courts or before the high court. This has been the general rule, but in exceptional circumstances, the court has entertained a new plea of facts for the first time. Number one, in Karanpura Development Company Limited versus K. Narayan Singh, the court did not allow the question whether a transaction concerning license with an agreement to lease in future was bad under Section 18 of the Bengal Court of Wards Act 1879 to be raised for the reason that the rates of salimi and royalty fixed there were less than the current market rates. The court stated that the said question was essentially a question of fact and hence could not be raised in appeal before the Supreme Court for the first time. Now there is second case law too. In Jagannath Behra versus Raja Harihar Singh, the court held that the question whether any special law or customs prevailed in the merged territory was one of the fact and could not be allowed to be urged for the first time before the Supreme Court. The principle that was laid down was that whether the determination of question raised required evidence in regard to the same, it would not be fair to allow the question to be agitated. And then in Venkataramana Devaru versus State of Mysore, the court did not allow a question to be raised for the first time whether the temple was a private one or not within the purview of Madras Act 13 of 1949, as the said point was not raised in the pleadings in the courts. An accused cannot be permitted to take up a contention for the first time before the Supreme Court that the food inspector had no authority to file a complaint if the contention has not been raised before the lower courts. The court held that if the accused had challenged the authority of the food inspector to file the complaint, the trial court would have gone into the same. This was essential a question of fact. In Gopinath Ghosh versus State of West Bengal, in an appeal against conviction and sentence, the appellant for the first time before the Supreme Court claimed that he was less than 18 years of age on the date of occurrence and as such entitled to the benefit under the West Bengal Children Act. The court held that considering the underlying intendment and socially progressive status, the plea of the accused ought to be entertained. The court called for a finding on the age from the session court. On the basis of the finding that the accused was less than 18 years, he acquitted the accused and the magistrate was directed to proceed as per West Bengal Children Act 1959. Now, so far as plea of law, a pure question of law is concerned, the court would generally permit parties to raise the same even if the same was not raised at any stage in the proceeding. In Badri Prasad versus Nagarmal, the court allowed a new point of law to be raised for the first time before it. In that case, a question as to contravention of Section 4, Subclause 2 of the Rewa States Company Act 1935 was raised for the first time in the Supreme Court. The court held that it was a pure question of law, not requiring the investigation of any fact, and hence could be raised in the Supreme Court and appeal for the first time. The court in Masalti versus State of UP stated that it may be concerned that if a point of fact which plainly arises on the record or a point of law which is relevant and material and can be argued without any further evidence being taken was urged before the trial court and after it was rejected by it, why not appealed before the High Court? It may be, in an appropriate case, be permitted to the appellants to ask this court to consider that point in an appeal under Article 136 of the Constitution. In State of Rajasthan versus Karmchand Thapar, this court held that the question of law, which can be decided on the material on record of the case, can be allowed to be raised at the stage of appeal by special leave under Article 136. In B.K. Bandkar Limited versus Municipal Committee, Damangaon, a new plea based on the Municipality Act was raised for the first time in the statement of case, and the court allowed it to be raised as it was a question of considerable importance and might be raised in other similar suits which are said to be pending. In Nairullah, Ganjan Furullah versus Municipal Board of Aligarh, the plea regarding the constitutionality of the legislation, even though it was not argued in the writ petition before the High Court, was allowed to be raised before the Supreme Court, as declining such a plea could lead to another writ petition challenging the constitutionality of the legislation, which was always open to the party. However, in this case, since the question was not decided by the High Court, the matter was remanded back to the High Court. So, a plea as regards lack of jurisdiction can be raised for the first time before the Supreme Court a plea that an application under Section 33 capital C, subclause 2 of the Industrial Dispute Act 1947 was barred by the limitation was allowed to be raised for the first time before the Supreme Court. The court held that though the plea was not put forward before the courts below, it would allow it to be raised as it was a pure question of law and could be decided on the basis of facts on record. Further, in this case, the party had filed an application seeking permission to raise the points of limitation, and the court held that the respondents were therefore aware that this point had to be raised by the appellant. However, there has been cases where the Supreme Court has not permitted questions of law to be agitated for the first time before it. In Cantonment Board Ambala versus Pyaralal, the question was raised for the first time that the magistrate acting under the section 259 of the Cantonment's persona designata and therefore his order was not revisable under section 435 oblique 439 of the Code of Criminal Procedure. The Act 1924 was a court held. Though the High Court may not have jurisdiction to interfere under Section 435, 439 of the Code of Criminal Procedure, it could certainly interfere with the order of the magistrate under Article 227 of the Constitution. Now, if this point has been raised before the High Court, it may very well be that the High Court might have considered the reference as if it was an application before it under Article 227 of the Constitution, in which case the High Court would have jurisdiction in the circumstances to interfere with the order of the magistrate. If it came to be to the conclusion that the magistrate had no jurisdiction under Section 259 of the Act, in these circumstances, we are not prepared to permit the appellant to raise this point before us at this later stage. Similarly, in a case, a plea that jurisdiction of the civil court was barred by the provision of MB Land Revenue and Tenancy Act, which was decided against the respondent for the first two courts and was given up before the High Court, was not to be permitted to be raised in the Supreme Court. So, this is all about which pleas can be taken and which cannot be taken. God bless you all. See you again. Sorry for little bit of disturbance in the video.